Hi, I'm attorney Amy Dohrendorf. In this video segment, I will be discussing with you how income is calculated for child support purposes in Arizona family law matters. Child support obligations are based on the Arizona Child Support Guidelines. Pursuant to the guidelines, the amount of support to be paid is calculated after considering many factors, including both parties' gross incomes. Under the guidelines, gross income is broadly interpreted. When calculating child support, the parents must include all sources of income from wages to rental income, interest on investments, spousal maintenance, and so on. Typically, any earnings that are not considered to be continuous or regular will not be considered income, such as infrequent and irregular bonuses, commissions, and overtime pay. Essentially, any income that was not earned on a continuous and regular basis will likely not be considered income for purposes of the child support calculation. In some cases, a parent is willfully or voluntarily unemployed or underemployed. If that is the case in your situation, the court may, and usually does, attribute the unemployed or underemployed parent an income for purposes of the child support calculation. Income is typically attributed based upon educational history, work history, previous earnings, and earning capacity. A vocational expert may be hired in order to assess the other parent's current employability, job skills, and potential earning capacity. In order to assess a parent's income, the court requires that each parent disclose financial information to one another. Each parent is required to disclose an affidavit of financial information, 2 most recent earnings statements, and the last 3 years of tax returns, including all schedules and W-2s. In addition to this, you are well within your right to seek the other parent's bank statements, financial account statements, property inventories, and credit card statements in order to assist you in determining the other parent's income. Through negotiations, parties are usually able to reach an agreement as to each parent's incomes, be it attributed or actual. In the event you are unable to reach an agreement regarding either your income or the other parent's income, then the court will have to decide the issue based upon evidence presented at the time of trial. In some instances, you may opt to hire an expert witness, such as a forensic accountant, to assist you with your inquiry and to testify on your behalf at the time of trial. A forensic accountant is often retained when you or the other parent is self-employed, making their income less obvious than the 1099 or W-2 employee. This is something we would discuss early on in your case to determine if it is a financially viable option and the degree to which it would further your cause. We have only scratched the surface in regard to determining income. It may seem like a daunting task, but we are able to assist you in this regard and can minimize your efforts so that you can focus on what's really important, you and your family. In parting, I always like to give my clients cost-saving tips. So when speaking about income and the discovery that goes along with it, I thought I'd share this tip with you. After hiring an attorney, it is extremely beneficial for you to have all of your financial information organized, copied, and prepared to give to your attorney as soon as possible. Label and organize your financial documentation so that your attorney is not spending time piecing together your financial portfolio. Provide your attorney with copies of your 2 most recent pay stubs, copies of all your credit card and financial account statements, copies of your last 3 years' tax returns, and your completed affidavit of financial information. If you have the opposing party's financial information, provide and label copies of that as well. Being organized and prepared not only helps your attorney determine income and understand the financial aspect of your case, but should also reduce legal fees and cost. This single tip can save you hundreds of dollars in your litigation.